Hello, everyone. We're going to wrap up Trump v. Barbara. So, this is the birthright citizenship case. So the court's definition also cannot be reconciled with the contextual evidence that would have informed the meaning of the Citizenship Clause. The court does not attempt to explain how its reading of the Citizenship Clause comports with the Civil Rights Act's citizenship provision. The court does not present evidence that the children of temporary visitors were not subject to any foreign power, as the Civil Rights Act required. Temporary visitors were subject to the foreign power of the government of their domicile. The court also does not present any evidence that the Citizenship Clause had a different meaning from the Civil Rights Act. As no party here disputes, the two provisions were agreed to have been synonymous with respect to foreigners. As the plaintiff's counsel put it, the framers were trying to do the same thing with the language in both. The court likewise cannot explain the evidence that citizenship in this country was instead based on domicile. It does not meaningfully engage with the congressional debates during which this provision was extensively discussed, and it has no account of why so many legislatures made so many statements irreconcilable with its view. In fact, the court does not even identify anyone who expressed the feudal principle in the relevant language, not subject to any foreign power or subject to the jurisdiction of the United States. The closest that it comes is Lynch v. Clark's use of the phrase within the jurisdiction, language that denotes territorial jurisdiction. But Congress conspicuously chose not to use that broader territorial phrase in the Citizenship Clause. Notably, the 14th Amendment elsewhere says that no state may deny to any person within its jurisdiction the equal protection of the laws. The Citizenship Clause does not use that territorial phrase. See brief of Professor Richard Epstein as amicus, explaining that the Equal Protection Clause refers to all persons within its jurisdiction, and that the phrase subject to the jurisdiction thereof means something other than within the jurisdiction. Thus, while jurisdiction can refer to mere territorial jurisdiction, which a government, of course, exercises over temporary visitors, the Citizenship Clause did not adopt that sense of jurisdiction. I would not interpret subject to the jurisdiction to refer to the exclusion of three bespoke categories of persons whose relationship to the sovereign was not described in those terms. There is a simpler interpretation of the text that was expressly endorsed by those closer in time to ratification. Children born to diplomats, hostile alien occupiers, and Indians in tribes were not citizens because they were not subject to the complete jurisdiction of the United States. For the same reason, the children of foreign temporary visitors, who were also not subject to the complete jurisdiction of the United States, were also not citizens. Practice and precedent immediately and long following ratification support the same conclusion. In constitutional law, this court often pays close attention to how government officials interpreted and applied a constitutional provision shortly after its enactment. Here, the executive branch, Congress, and the judiciary all largely interpreted the Citizenship Clause to require domicile in the decades following ratification. The executive branch regularly denied citizenship to the children of temporary visitors under the Citizenship Clause. The executive branch's position from the outset was that the Citizenship Clause excluded the children of aliens who were not subject to the complete jurisdiction of the United States. Therefore, a child born in the United States but domiciled abroad was on his birth subject to a foreign power and not subject to the jurisdiction of the United States. Many executive decisions under the Citizenship Clause denied citizenship to children born but not domiciled here. In recorded reasoned decisions, the Hayes, Cleveland, and Harrison administrations, in accordance with the opinion of President Grant's Attorney General, all denied citizenship to children born in the United States but not domiciled here, who also did not satisfy any of the exceptions to the court's rule. On the court's account, each of these administrations, Republican and Democratic, over the course of multiple decades and close in time to ratification, acted in defiance of the Constitution, seemingly without objection. Against this settled course of practice, the court can find only a single executive decision from the entire 19th century that it believes supports its interpretation. But in that case, the executive branch ultimately ruled that the claimant, Francois Heinrich, was not a citizen. Heinrich was born on American soil and did not fall into any of the court's three exceptions, but the Secretary of State Hamilton Fish still concluded that he was not an American citizen because he resided in Austria. The court understands the executive branch The court understands the executive branch to have concluded that Heinrich was originally clothed with American nationality, but then lost that citizenship upon returning to his domicile abroad. Even the court is thus forced to embrace an interpretation of the Citizenship Clause that allows the political branches to deny citizenship to persons born here to temporary visitors. On that interpretation, the political branches can deny citizenship to such persons once they return home. Beyond that single case, the court does not dispute that the many other 19th century executive decisions were incompatible with its view, and it has found no examples of the executive branch actually affording the privileges of citizenship under the Citizenship Clause to a person born here while domiciled abroad. The executive branch instead repeatedly took the position that the Citizenship Clause required domicile. Congressional practice supports the same conclusion. Early congressional enactments provide contemporaneous and weighty evidence of the Constitution's meaning. Congress could have enacted a statute that referred to the court's three categories of exceptions. Instead, in 1870, the Reconstruction Congress reenacted the Civil Rights Act, which expressly excluded all persons subject to any foreign power. Once again, a foreigner who was not domiciled here remained subject to a foreign power, namely his home country. Nobody in Congress, as far as I am aware, argued that this exclusionary language violated the Citizenship Clause. Congress left the language excluding persons subject to any foreign power in place until 1940. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. And that was in 1875. And then USC subsection 1 in 1934 edition. All persons born in the United States and not subject to any foreign power are declared to be citizens of the United States. It was the governing rule for the first 72 years after ratification. Such contemporaneous legislative exposition of the Constitution acquiesced in for a long term of years fixes the construction to be given its provisions. The court has no explanation for the Reconstruction Congress's 1870 decision to exclude from citizenship all persons subject to any foreign power. It appears to concede that it cannot reconcile its interpretation of the Citizenship Clause with that statute, and the court recognizes that every child born to temporary visitors was subject to a foreign power. According to the court, then, Congress defied the Citizenship Clause immediately after enacting it. Early judicial precedent supports the same conclusion. In 1873, 5 years after ratification, this court described the Citizenship Clause in a manner that is, on the court's view, indefensible. It stated that the clause excluded from its operation children of citizens or subjects of foreign states born within the United States. The court rejects that position today, but declines to address its previous interpretation. Likewise, in 1884, this court interpreted the Citizenship Clause to require that a person be not merely subject, in some respect or degree, to the jurisdiction of the United States, but completely subject to its political jurisdiction, owing it direct and immediate allegiance, and owing no allegiance to any alien power. The court also rejects that position today. Decades of post-ratification scholarship interpreting the Citizenship Clause confirm this view. Most interpreters of the Citizenship Clause concluded that it required domicile. The Citizenship Clause, scholars said, required that a child born here of alien parents show that those parents were permanently domiciled within the United States. It excluded those with allegiance to some other government. Children born in the United States, their parents not being here domiciled, are not citizens. The words subject to the jurisdiction thereof excluded the children of foreigners transiently within the United States. Children born in the United States to foreigners here on transient residence were not subject to the jurisdiction of the United States. A child born here to parents temporarily residing was not a citizen of the United States because it was not subject to its jurisdiction. Many more agreed. The Citizenship Clause excluded the children of foreign subjects, born while the latter transiently sojourn here. The children of foreigners in transient residence are not citizens. And then if a stranger or traveler passing through the country has a child born here who goes out of the country with his father, such a child is not a citizen. And children of foreigners in transient residence are not citizens. One born of parents temporarily in our country is not One born of parents temporarily in our country is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so the elements of national jurisdiction are wanting. The Citizenship Clause excludes children of persons passing through or temporarily residing in this country. The court does not attempt to match this post ratification evidence. To the contrary, the court acknowledges that, at least by the 1880s, the Citizenship Clause was understood to require domicile by the government, the executive branch, the State Department, scholars, and treatises. The court, though, proposes that this widespread understanding was not evidence of the original public meaning of the Citizenship Clause, but a rebellion against it. The scholars, courts, and government officials who held that domicile was required, the court says, were engaged in a law reform effort. Their motive, the court seems to say, was to deny citizenship to Chinese immigrants, especially around the election of President Cleveland, the first Democrat to hold the office since the Civil War. On this basis, the court suggests ignoring the considerable post-ratification practice and scholarship that is incompatible with its view. The court's account does not make sense. To begin, the post-ratification evidence against the court's view begins not nearly 2 decades after the 14th Amendment's ratification, but immediately. Well before the court has any explanation for a departure from its view, all 3 branches of the federal government had already rejected it. In 1870, Congress interpreted the Citizenship Clause to require that a child born here be not subject to any foreign power. In 1873, the Supreme Court interpreted the Citizenship Clause to exclude from its operation children of citizens or subjects of foreign states born within the United States. And the same year, President Grant's Attorney General interpreted the Citizenship Clause to exclude the children of aliens over whom the United States had limited jurisdiction, even though they were born here. If all 3 branches of the federal government were not enough, many other concurred during these first 2 decades. The court cannot explain why, in the 1870s, William Robinson wrote that children born within the territory of the United States of alien parents were not citizens unless permanently domiciled within the United States. Why California excluded from citizenship children of transient aliens? Why Representative Ebenezer Hoar, President Grant's first Attorney General and one of the nation's most eminent jurists, interpreted the Citizenship Clause to require domicile. And why the executive branch denied citizenship to a child born here but domiciled abroad. The court likewise cannot explain why, in 1880, Thomas Cooley, who wrote that the Citizenship Clause excluded children who had any allegiance to some other government. The court's theory does not even explain the later evidence that it characterizes as a revisionist project. If, as the court suggests, various government officials and scholars were trying to prevent the children of Chinese immigrants from being citizens, then they would not have proposed a domicile requirement alone. They would have needed to propose a citizenship requirement. As Wong Kim Ark exemplifies, many Chinese immigrants were already domiciled here. They simply were ineligible for formal naturalization. Accordingly, when the executive branch did attempt to exclude the Chinese in the 1890s, it argued against the domicile rule. Meanwhile, as far as I can tell, the people excluded by the domicile requirement were not Chinese, but mostly European. Children such as Joseph Speck of Switzerland, Ludwig Hosding of Saxony, Richard Greiser of Germany, Frederick de Bury of Austria, and the child of Mary Devereux of Ireland are unlikely targets of a campaign of anti-Chinese discrimination. The more likely explanation for why so many Americans stated that the Citizenship Clause required domicile is that the Citizenship Clause required domicile. Many other indicators of original public meaning support the domicile requirement. I briefly address 3. First, if the court were right that the Citizenship Clause did not require domicile, then it would have increased dual nationality, which would have provoked concern among 19th century Americans. The United States has long recognized the general undesirability of dual allegiances. At the time of ratification, exclusive loyalty to the United States had long been a fundamental element of American citizenship. The view at the time was that a nation should as soon tolerate a man with 2 wives as a man with 2 countries. Opposition to dual nationality was especially strong after the Civil War. The country had just emerged from a civil war that cost the lives of over 600,000 men due to a treasonous denial of allegiance to the United States. Going forward, there would be no national citizenship absent a reasonable expectation of national allegiance. In 1868, an 1868 congressional report explained that if a person was a national or of both his home country and the country of his birthplace, it could expose him to competing claims for compulsory military service or could cause him to be summoned to fight for governments with which he has no connections and against those with which his fortunes are indissolubly united. The intimate association of those who are claimed as subjects of foreign governments is such as to put in peril the rights or peace of all. Accordingly, this court has long resisted reading the Citizenship Clause to inhibit the political branch's ability to address problems attendant on dual nationality. A rule that recognizes the citizenship of children born to temporary visitors would have increased dual nationality. At the adoption of the Citizenship Clause, as today, most nations treated the children of their citizens born while temporarily abroad as citizens. As a result, a child born in the United States of a temporary visitor would have immediately been a citizen of his home nation. If the court's interpretation were correct, the child would immediately also become a dual citizen. It is unlikely that the Reconstruction Congress constitutionalized such a rule. By contrast, the domicile requirement mitigated the problem of dual nationality. Each person had one and only one domicile, so tying citizenship to domicile avoided dual citizenship. Second, the domicile rule aligns national citizenship with the long-standing rule for state citizenship. Even after the court's decision today, Americans are citizens of only the state of their domicile, even if it is not the state of their birth. No one doubts that a child born to New Yorkers on vacation in Florida would be treated as domiciled in and a citizen of New York. For the same reason, one would think that a child born to Canadians on vacation in Florida should not be a citizen of the United States. The court, in other words, rejects and is bewildered by an approach to citizenship that is, in fact, the one we still know best. Third, the domicile rule would make the Citizenship Clause accord with America's treatment of its own domiciliaries abroad. America itself has long taken the position that children of American citizens born on temporary visits abroad are American citizens. Such children were long considered American citizens because their parents were domiciled in America. It is unclear why the same reasoning should not apply in the other direction. The court's alternative history is mistaken. The court's theory of the Citizenship Clause stands on three main pillars: Calvin's case, Lynch v. Clark, and Wong Kim Ark. None can justify the court's decision today. The first pillar of the court's theory is Calvin's case, a 418-year-old English common law decision. Calvin's case held that a child born in Scotland could hold land in England. According to the court, Sir Edward Coke's separate opinion in Calvin's case established the common law principle called jus soli, pursuant to which people owed perpetual feudal allegiance to the King of England if they were born within the dominions that he owned. This principle applied to all persons born on the land, not just those domiciled there. As the court tells it, in 1608, feudal principle, as described by Coke, was adopted as the law of citizenship in America and then incorporated by reference in the Citizenship Clause. The English principle was a rule of feudal servitude, not a rule of citizenship. In England, there was no such thing as a citizen. The English principle instead determined a person's permanent feudal bondage to the king, which he could not unilaterally abandon. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed it to the king, and it was born with the child, and only ended in the grave. A relation of master and servant. Under the feudal system, every owner of lands held them in subjection to some superior or lord. Citing Blackstone, the lord would protect the vassal in the enjoyment of the territory granted him, while the vassal would be faithful to the lord and defend him against all his enemies. The English feudal principle was not accepted by the American governments. As Justice Alito explains, the principle that birth on the soil made a person perpetually bound to the king was premised on the theory that the king was anointed by God to rule the people like children. John Adams famously wrote that the feudal theory meant that the common people were held together in herds and clans in a state of servile dependence on their lords, in a state of total ignorance of everything divine and human. They began their settlements and formed their plan both of ecclesiastical and civil government in direct opposition to the feudal system. They then dissolved all allegiance to the British crown, and then and they let set up and they set up a new system of government in which the people were not regarded as servile dependents. Instead, the people were sovereign, and the government derived its legitimacy from them. In this new system of government, feudalism had no place. The soil did not belong to the government, but to the people. And those who were born on it did not owe the government a lifetime of obedience, did not owe the government a lifetime of obedience or servitude. Obedience or servitude. The Reconstruction Congress expressly opposed the feudal principle that the court claims that it adopted. As its Committee on Foreign Affairs saw the matter, there is nothing American in the oath of the land barons of England. It described the English rule's claim of indefeasible allegiance and perpetual service as the symbol of feudalism and force. Instead of the feudal principle, the congressional report explained that American law viewed people as taking on a new citizenship, as relevant here, when they changed their domicile. The same year that the Citizenship Clause was ratified, Congress passed a statute rejecting the feudal principle and explaining that it supported the right of all persons to expatriate and change their citizenship. In fact, by the 1840s, even English law had evolved. England had moved on from the darkness of the Middle Ages, and as the subjects of one kingdom began to migrate into and reside in other countries, had begun to attach a newfound importance of the law of domicile. Well before the Citizenship Clause, this court explained that the courts of England had decided that a person who removes to a foreign country, settles himself there, and engages in the trade of the country, furnishes by these acts such evidence of an intention permanently to reside there as to stamp him with the national character of the state where he resides. A year after the Citizenship Clause, a renowned English case declared that a person's civil status, by virtue of which he has ascribed to him the character of a citizen of some particular country, is governed universally by one single principle, namely that of domicile. The second pillar of the court's theory is Lynch v. Clark, a single state court case about citizenship. Thomas Lynch was a successful businessman in New York. When he died, he had no will and no children. Shortly after he died, his brother Bernard and his niece, through another brother, Julia, moved to New York from Ireland. The New York legislature then passed a special statute giving Lynch's property to Julia Lynch, subject only to the rights of the heirs at law of Thomas Lynch. The legislature then passed another special statute giving Lynch's property to Bernard Lynch, save for the claims of heirs of Thomas and the existing rights of Julia Lynch. Lynch's business partner, John Clark, also claimed a right to property in his estate. Bernard then brought a bill in equity against both Julia and Clark. Julia cited a special statute giving her inheritance rights, but also argued that because she was born in the United States, she inherited all of Thomas's property and had other equitable entitlements. That argument turned on a state law bar on aliens inheriting real property, so Julia argued that she was not an alien. She argued, among other things, that she was not an alien because she was in fact domiciled in the United States at the time of her birth. Her father came here with an intention to remain and thereby changed his domicile. The assistant vice chancellor, who was assigned to the case, held 6 days of argument, during which Julia Lynch's citizenship was not then made a very prominent point. After argument, the assistant vice chancellor became so impressed with the importance of the question upon the citizenship of Julia Lynch that he asked for supplemental briefing on the issue. He then wrote a long opinion explaining his theory of American citizenship, which concluded that Julia Lynch was not an alien, but a citizen, and therefore entitled to inherit the property. Within a year, New York replaced the law that the assistant vice chancellor interpreted with a new law that simply made aliens ineligible to inherit property. The state shut down his court 2 years later. The court's reverence for Lynch v. Clark is not commensurate with its importance. The state shut down his court 2 years later. The offices of chancellor, vice chancellor, assistant vice chancellor are abolished. The court's reverence for Lynch v. Clark is not commensurate with its importance. Lynch was not a precedent of this court, or any federal court, or any state appellate court, or even a court of law. Instead, it was decided by a New York assistant vice chancellor in a court of equities equivalent to a trial court. The assistant vice chancellor, much like a magistrate judge, had the power to hear preliminary motions for the suppression of testimony and cases referred to him by the chancellor. The assistant vice chancellor's opinion on Julia's citizenship was apparently not reviewed by any appellate court. Lynch also did not interpret the Citizenship Clause, a statute using the same language as the Citizenship Clause, or even a statute that remained in effect at the time of the Citizenship Clause. Instead, it interpreted a New York state law. The state law was replaced immediately after Lynch. If a single expressly limited opinion from a specialized intermediate federal court does not establish a well-settled meaning that the court can assume Congress incorporated into a federal statute that uses the same language, then a single state trial equity court decision interpreting a different law certainly does not do so. Lynch also lacked staying power. By the time of the Citizenship Clause, New York's higher courts had all but abrogated it. In Ludlam v. Ludlam, a New York appellate court held that the children of those traveling or sojourning abroad, though born in a foreign country, are not born under the allegiance and are an exception to the rule which makes the place of birth the test of citizenship. That decision was affirmed by the New York Court of Appeals, which stated, "By the law of nature alone, children follow the condition of their fathers and enter into all their rights. The place of birth produces no change in this particular." See Ludlam v. Ludlam, and then also Mayton, immigration. Shortly thereafter, in Ludlam v. Ludlam, that state's highest court, with all justices concurring, spoke differently, saying that birthright citizenship depended on parentage rather than the boundaries of the place. When the New York legislature authorized a committee to codify its laws in 1860, the codification defined birthright citizens as all persons born in this state and domiciled within it, except the children of transient aliens and of alien public ministers and consuls. Then, during the 14th Amendment debates of the 39th Congress, Lynch went unmentioned. It was only during the Civil Rights Act debates that Lynch appeared a single mention by a member who played no role in drafting the 14th Amendment. And then also see Epstein, The Myth of Birthright Citizenship. At the time of the debates over the ratification of the 14th Amendment, moreover, Lynch v. Clark appeared to play no role. So, while this court's opinion invokes Lynch 13 times in 26 pages, the entire Reconstruction Congress, in the combined course of deliberations over the Civil Rights Act and the Citizenship Clause, mentioned it only once. The third pillar of the court's theory is Wong Kim Ark. The question before the court today, whether the Citizenship Clause requires the president to recognize citizenship for the children of all lawful temporary visitors and illegal aliens, was not before the court in Wong Kim Ark. Instead, the Wong Kim Ark court held that someone born in America to parents domiciled in the United States was a citizen. It rejected the government's argument that Wong's parents had to be citizens for him to be a citizen at birth. The citizenship order is fully consistent with this decision. Under the order, people like Wong remain citizens, and the government today nowhere urges the position that it took in Wong Kim Ark. To the contrary, it invokes authorities that the government in Wong Kim Ark opposed. The court nonetheless leans heavily on dicta from the majority opinion in Wong Kim Ark, which it takes to have established that Wong's domicile was irrelevant, and that he, a lifelong American, was indistinguishable from a person who had no meaningful ties to America. The court does not ordinarily put so much weight on past decisions' discussion of matters not before the court. It is a maxim not to be disregarded. This court has always admonished that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. Thus, if they go beyond the case, they may be respected but ought not to control the judgment in a subsequent suit when the very point is presented for decision. Instead, we emphasize our opinions, dispose of discrete cases and controversies, and they must be read with a careful eye to context. After all, the question actually before the court is investigated with care and considered in its full extent, but other principles which may serve to illustrate it are considered in their relation to the case decided, but their possible bearing on all other cases is seldom completely investigated. And then see also a Trump v. Cook and the slip opinion. We review judgments, not statements and opinions. Nor is Wong Kim Ark's dicta so clearly on the court's side. After a long discussion with many internally inconsistent statements, Wong Kim Ark's final statement of the rule comported more closely with the citizenship order's application to temporary visitors than with the court's view. The Wong Kim Ark Court concluded that the Citizenship Clause grants citizenship to all children here born of resident aliens, with the exceptions or qualifications of 1. Children of foreign sovereigns, 2. Children of foreign ministers, 3. Children born on foreign public ships, 4. Children of enemies within and during a hostile occupation of part of our territory, and 5. Children of members of the Indian tribes owing direct allegiance to their several tribes. It then reaffirmed that the amendment, in clear words and manifest intent, includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Wong Kim Ark also repeatedly emphasized that its holding was limited to domiciliaries. It did so 7 times in the first paragraph and repeatedly after that. And succinctly, Wong Kim Ark itself invoked the court's oft-repeated reminder that general expressions that go beyond the case should not control the judgment in a subsequent suit when the very point is presented for decision. This is not quite no, 1,000 times no, but should have sufficed to dissuade the court from invoking the case with respect to the distinct legal and factual issues presented here. It is not surprising that Wong Kim Ark limited its holding to domiciliaries. The government in Wong Kim Ark stipulated that Wong was domiciled in the United States and argued that domicile was irrelevant. The court thus had little reason to consider what rule would apply to a temporary visitor. The court was hardly likely to upset the consensus that the Citizenship Clause required domicile in a case where the issue was irrelevant given Wong's domicile in this country. If Wong Kim Ark were so simple in establishing the court's rule as to temporary visitors, that meaning was seemingly lost on many. As a Department of Justice report confirmed in 1910, a dozen years after Wong Kim Ark, it has never been held, and it is very doubtful whether it will ever be held, that the mere act of birth of a child on American soil to parents who are temporarily in the United States operates to invest such child with all the rights of American citizenship. The Citizenship Clause reference to jurisdiction does not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but instead that larger jurisdiction, which, though difficult to define, is well known and understood. The difference between the jurisdiction which is exercised over a visitor and that over one domiciled. In the years following Wong Kim Ark, the Citizenship Clause was generally understood as limited to children born of alien parents not temporarily resident here, but permanently domiciled. Nothing in Wong Kim Ark changed the consensus that children born in the United States to foreigners here on transient residence are not citizens, because by the law of nations they were not, at the time of their birth, subject to the jurisdiction of the United States. See, for example, Hall International Law. It would seem that the children of foreigners in transient residence are not citizens. And then Wharton, a conflict of laws. Citizens must be domiciled, Guthrie, permanently domiciled and residing here. And that's Westlake International Law. When a father is in the union for a transient purpose, his children born within it have his nationality, citing Black. No citizenship for a child of a stranger or traveler passing through the country or temporarily residing here, and that's Bellett, leading cases on international law. Children of foreigners in transient residence are excluded from citizenship even though born within the United States. As for the remainder of the court's reasoning, much of it is self-defeating. To begin, the court invokes Frederick Douglass's statement that the Constitution knows all the human inhabitants of this country as the people. But temporary visitors are not inhabitants. To be an inhabitant, a person must be domiciled. See Thomas Cooley's Constitutional Limitations. One is an inhabitant, resident, or citizen at the place where he has his domicile. And Crawford v. Wilson, inhabitant is defined to be one who has his domicile in a place, as distinguished from an occasional lodger or visitor. And Sears v. Boston, the domicile or the fact of being an inhabitant. And then Littlefield versus inhabitants of Brooks, where he was an inhabitant, where he has his domicile. And Frederick Douglass himself argued that blacks were citizens because they were not comparable to temporary visitors. They were not aliens, they were not exiles, and they were not strangers. Instead, they were Americans, he said, who, unlike temporary visitors, owed equal allegiance to the same government. Likewise, the court invokes Attorney General Bates' statement that persons born here were prima facie citizens, but the court does not seem to be aware that this phrase corresponds to the rule of domicile that the court rejects. See President and Fellows of Harvard College. The place of birth is prima facie evidence of domicile. And see also Overseers of Reddington versus Overseers of Tewksbury. If a person's parents were domiciled abroad, then a prima facie case was overcome. Beyond these statements, the court mainly emphasizes that the children of temporary visitors owed a partial allegiance to and were owed partial protection from the sovereign. That undisputed fact does not demonstrate that the children of these visitors were citizens. To the contrary, Senator Trumbull explained that the Civil Rights Act was written to avoid this very misunderstanding. The act said, not subject to any foreign power, instead of owing allegiance to the United States precisely because temporary visitors owed a partial allegiance to the United States, and he did not want anyone to mistakenly conclude that the act included the children of temporary visitors. The language chosen thus excluded temporary sojourners, who continued to owe allegiance to their native country. Finally, the court relies on general statements without recognizing that those statements are also compatible with my view of the Citizenship Clause. The Citizenship Clause indeed followed the pre-existing law, but the pre-existing law was based on domicile. Children born here to foreign parents indeed were generally citizens, but that is because they were generally domiciled here, and citizenship did indeed almost always follow birthplace. But that is because birthplace almost always followed domicile. The court's response to my view also undermined its own. The court's responses to my view also undermine its own. The court criticizes my view for depending on the parent's status, not the child's. But the court's view depends on the parent's status too. The court, for example, excludes from citizenship the children of representatives of foreign sovereigns or enemy invaders. Unless newborn babies are serving as international diplomats, the court's account thus turns on parent status. Along the same lines, the court asks why words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. But again, if that is a problem, then it is one for the court's theory as well. After all, the court's exceptions for foreign representatives, Indians, and invading enemies do not appear in the clause either. Finally, the court suggests that domicile is a difficult concept to apply, but domicile is, of course, a concept widely used in both federal and state courts for jurisdiction and conflict of laws purposes, and its meaning is generally uncontroverted. And the court's concept poses its own administrability questions. The court never explains, for example, what happens when a child is born to a citizen and a diplomat, or to a citizen and a member of an invading army. The court also suggests that my interpretation of the Citizenship Clause is not consistent with the Civil Rights Acts, not subject to any foreign power requirement, because a foreign nation can purport to exercise power over its original citizens even after they establish a domicile here. But the court's interpretation of the Citizenship Clause does not even attempt to be consistent with the Civil Rights Act requirement, since the children of temporary visitors are clearly subject to the foreign power of their homeland. Regardless, the court is wrong about domiciliaries remaining subject to the foreign power of their country of birth. Although their nation of origin might purport to exercise jurisdiction over them, the United States would not have had to recognize that authority as lawful once those persons were domiciled here. The court ultimately denigrates the evidence in support of my position as scant. I see it differently. The court cites little evidence from the Reconstruction Congress that gave us the Citizenship Clause, and its other 19th century evidence is slim in comparison. As for the evidence in support of my position, it is substantial. Representative Bingham, the architect of the 14th Amendment, believed that the Citizenship Clause would not apply to the children of temporary visitors. Senator Trumbull, a principal champion of the amendment, agreed. Jacob Howard, who introduced the Citizenship Clause, agreed. Congressman after congressman during the legislative debates agreed. Congress in 1870 agreed. President Grant's Attorney General agreed. President Grant's Attorney General agreed. President Grant's Attorney General before that agreed. The Supreme Court in 1873 agreed. State legislatures agreed. Executive branch decision makers over the course of multiple decades agreed. Justice Miller agreed. Thomas Cooley agreed. A battery of other eminent scholars agreed. And the great Justice John Marshall Harlan on 3 separate occasions agreed. Once again, I am quite comfortable in the company I keep. Before concluding, I briefly address plaintiff's argument that even if the citizenship order has at least some lawful applications consistent with the Citizenship Clause, it is not consistent with the statutory citizenship provision in force today. The court gives no independent import to the statutory citizenship provision, and I would not either. From 1866 until 1940, the statutory citizenship provision required that a person claiming citizenship based on birth in the United States be not subject to any foreign power. That language from the Civil Rights Act, like the language of the Citizenship Clause, required that a person claiming citizenship have a domicile in the United States. So both the statute and the Constitution required domicile until at least 1940. The Nationality Act of 1940 codified the existing law by enacting the Citizenship Clause text. By the early 1930s, the American law on nationality was expressed in a large number of provisions scattered throughout the statute books. President Roosevelt designated a committee to review existing nationality laws and, as relevant here, to codify those laws into one comprehensive nationality law. As a result of that process, Congress enacted the Nationality Act in 1940. The Nationality Act was the first attempt ever made since the founding of our republic to codify and unify all the laws of the United States relating to the important subjects of nationality and naturalization. A codification of existing law does not change the law unless it does so clearly. When legislatures consolidate their statutes at large into a code, they often revise the wording of the prior statute to provide for consistency of expression. But that revision does not result from legislative reconsideration of the substance of codified statutes. The same is true for legislative restyling exercises short of codification. Such new language does not amend prior enactments unless it does so clearly. The Nationality Act's citizenship provision codified the Civil Rights Act's not subject to any foreign power requirement and the Citizenship Clause's subject to the jurisdiction requirement. It did so by borrowing language from the Citizenship Clause, which granted citizenship to all persons born in the United States and subject to the jurisdiction thereof. By using language that tracked the Citizenship Clause, Congress did not clearly change the law. It would be surprising to discover that Congress departed from the constitutional standard by enacting the exact constitutional language. The 14th Amendment was enacted in the wake of the Civil War, with the one pervading purpose of securing equal citizenship for the freed slaves. It was enacted, as Justice Harlan wrote, to secure to a race recently emancipated the civil rights that other citizens enjoyed. This court has time and again denied Americans that promise. Shortly after the amendment was ratified, this court deprived black citizens of the right to peaceably assemble and to keep and bear arms. See United States v. Cruikshank and see McDonald. A little later in Plessy, the court upheld the subjugation of black citizens in the form of state-coerced racial segregation. When it had an opportunity to correct that profound error, it did so narrowly. See Brown v. Board of Education. It then used that very decision to justify busing American children to different schools based on their race. See Swan v. Charlotte Mecklenburg. And until recently, this court continued to selectively enforce our colorblind constitution, including by allowing state-coerced racial discrimination in public education, for example, Grutter v. Bollinger, and compelling states to draw political districts on the basis of race, for example, Allen v. Milligan. Meanwhile, the court has repurposed the 14th Amendment to protect its own set of preferred rights that the Reconstruction Congress never contemplated and that cannot find support in its text. Today, the court does so again by recognizing a constitutional right to citizenship for the children of all foreign birth tourists and illegal aliens. I am not sure that today's opinion will stand the test of time. The Citizenship Clause added greatly to the dignity and glory of American citizenship. Today's opinion devalues that citizenship. I respectfully dissent. Justice Alito dissenting. This is one of the most important decisions in the history of the court, and in my judgment, the court has made a serious mistake. As interpreted by the court today, the 14th Amendment confers citizenship on virtually everyone who happens to be born in this country, including the children of birth tourists, women who come here solely for the purpose of giving birth to a child and then promptly return home. Careful analysis of the text of the 14th Amendment and the process that led to its adoption shows that it does not degrade the concept of United States citizenship in this way. Instead, the 14th Amendment confers citizenship on only those children who, at birth, owe allegiance solely to this country. Respecting this interpretation would not require uprooting the millions of children who were born here to mothers who entered or remained in this country illegally. Those children are not responsible for their parents' violation of our immigration laws, and their plight is the result of a long period during which a cadre of actors, executive branch officials, states and cities, and a variety of private groups sent the message to would-be immigrants that our immigration laws should not be taken too seriously. This message, coupled with ineffective or unenthusiastic enforcement, spurred massive illegal immigration and the growth of a large contingent of people who were born here to mothers unlawfully present in this country. Some members of this group have lived here for years, and they have a strong moral claim to be able to remain in the land where they grew up. Congress can and should address their situation. The 14th Amendment dictates who must be a citizen, but it does not address who may be a citizen by act of Congress. Congress has conferred citizenship on many people who are not made citizens by the 14th Amendment, including children born abroad to American citizen parents. These people and the millions of immigrants who have been naturalized are no less American than those who are fortunate enough to be born here. For these reasons, the original meaning of the 14th Amendment does not require inhumane results, and we should not adopt an erroneous interpretation of the 14th Amendment simply out of fear of the consequences of rocking the boat or as a reaction to current immigration policy. Nor should we take the position that our hands are tied by dicta in a sprawling 19th century opinion that is, to put the point gently, very far from a model of careful judicial craftsmanship. Too much is at stake. United States citizenship is precious. Anyone who has attended a ceremony where citizens are naturalized can see that message on the faces of those who take the citizenship oath. Before saddling the nation with a medieval rule, we had better be certain the Constitution requires it. The court's account of the birthright citizenship rule in American law is roughly as follows. After American independence, the British rule of birthright subjecthood was modified in just one way, to take account of Indians who lived under tribal governance. But otherwise, the rule was transplanted intact to American soil. As modified, the rule was that a child born in this country is automatically an American citizen unless the child is born to tribal Indians or to a diplomat with immunity from legal process. During the period before the Civil War, the rule's status was firm. After the Civil War, Congress codified the rule in subsection 1 of the 14th Amendment. And in United States v. Wong Kim Ark, this court issued a binding precedent confirming what Congress had done. Every step of this story is incorrect. The Declaration of Independence repudiated the foundation on which the British rule was based. From 1776 until the eve of the Civil War, the status of the rule in this country was unsettled. There is no evidence establishing that the Constitution's references to citizens incorporated the British rule, and until the eve of the Civil War, there was little litigation about the meaning of American citizenship. After the war, Congress finally adopted a constitutional provision, subsection 1 of the 14th Amendment, making certain persons citizens at birth, but that provision differed substantially from the British rule. It specified that a person born here is not a citizen unless his allegiance to the United States is unimpaired by any obligations to a foreign power. And while Wong Kim Ark included dicta suggesting that the 14th Amendment incorporates the British rule, its actual holding was much narrower. And under that interpretation, respondents' challenge to Executive Order number 14160, protecting the meaning and value of American citizenship, fails. According to the court, the 14th Amendment's Citizenship Clause codified the British rule of birthright. of birthright subjecthood with only one new exception, which was needed to accommodate the unique status of American Indians. That is a curious claim, and it is ironic that the court should embrace it only days before we celebrate the 250th anniversary of our Declaration of Independence, which emphatically renounced the foundation on which the British rule rested. That rule did not concern citizenship. There was no such thing as a citizen of England, Scotland, or Ireland. The inhabitants of the British Isles were the king's subjects. As Sir Edward Coke explained in Calvin's case, they acquired that status automatically at birth, and they retained it, like it or not, until they died. Even a subject who abjures the realm oweth the king his allegiance. This status arose from a feudal understanding of the origin of governmental authority and the relationship between those who govern and those who are governed. The king's authority was understood to come from God. As Coke put it, a king ruled by the law of nature, and birth established the bond between king and subject, just as birth establishes the bond between parent and child. In Calvin's case, the question was whether a man born in Scotland was a subject of King James I of England, who acceded to the thrones of both Scotland and England before the man's birth. In a famous speech to Parliament, James I forcefully explained his views about the source of his authority and his relationship with his subjects. The king, he proclaimed, sits upon God's throne and is the father of his people. This theory of monarchical power and the status of the people provided the foundation on which the rule of birthright subjecthood stood. Just as a person automatically acquires at birth all that is entailed by the relationship between parent and child, a person born within the king's dominion automatically became the king's subject. This meant that the subject acquired a duty of obedience to the king, and the king owed a duty of protection to the subject. This relationship was not based on consent, and a subject could not shed it. In this system of soil and servitude, the court sees emancipation, but our founders disagreed. The Declaration of Independence emphatically rejected the British theory of government. It proclaimed that governments derive their just powers from the consent of the governed, not divine right, and it absolved the people of the United States from all allegiance to the British crown. With its foundation blown away, the British rule of birthright subjecthood was not suited for easy incorporation into American law. In addition to the incompatibility of its theoretical foundation, two distinctively American practical problems stood in the way. The first was the problem of slavery and, more broadly, of race. In England itself, the number of slaves had never approached American dimensions. Just 4 years before the American colonies declared independence, Lord Mansfield's decision in Somerset v. Stewart denied that slavery had any common law foundation. And see the English report, proclaiming that slavery was so odious that nothing can be suffered to support it but positive law, and it would soon disappear. In the United States, on the other hand, nearly 700,000 lived in slavery, roughly one-fifth of the country's population, according to the first census in 1790. And since the contemporary definition of a citizen was a freeman of a city, not a slave. It was obvious that neither the Articles of Confederation nor the Constitution, both of which allowed slavery to continue, recognized the members of this sizable population as citizens. Even for the free black population of the United States, there was substantial opposition to application of the British rule. Many states, both in the South and Midwest, restricted the rights traditionally associated with citizenship, such as the ability to settle, vote, and serve as a witness in court, to white residents. And there was some federal support for this understanding of citizenship. In Britain, on the other hand, as the court notes, the common law did not take account of race. The second problem was the unique legal status of Indian tribes in the United States. Under the clause of the Constitution allocating seats in the House of Representatives and presidential electors, Indians not taxed were excluded from the body politic and thereby denied citizenship. This provision did not require census takers to determine whether individual Indians owed or paid taxes. Instead, the phrase referred to those Indians who retained their traditional way of life. They lived in their own communities under tribal law and enjoyed the privilege of total immunity from state taxation. It is hard to find estimates of the size of this segment of the population at the end of the 18th century, but it was certainly significant. The existence of these two big carve-outs refutes any argument that the British rule was transplanted without modification to American soil. and any attempt to implant some version of that rule here also faced the problem of applying it to a nation that, unlike Britain, had a written constitution and a federal system. In Britain, the rule of birthright subjecthood was part of the common law and thus could be changed by Parliament whenever it chose. If the rule was transplanted across the Atlantic, would it have a similar status here? Would it be part of the common law that state legislatures or courts could alter or abandon? See Van Ness v. Packard. Americans adopted only that portion of the common law which was applicable to their situation. Alternatively, did the rule have some status under federal law? Numerous provisions of the Constitution use the term citizen. See Article 1, subsection 2, Clause 2, qualifications of members of the House of Representatives. Article 1, subsection 3, Clause 3, qualifications of senators. Article 2, subsection 1, Clause 5, presidential eligibility. Article 3, subsection 2, Clause 1, subjects of jurisdiction. Article 4, subsection 2, Clause 1, privileges and immunities. Did all these provisions incorporate the British rule of birthright subjecthood? In this case, because we are concerned with the meaning of citizenship under the Constitution, it is the second alternative that is important for present purposes. In Lynch v. Clark, a decision on which the court, respondents, and many amici heavily rely, the Assistant Vice Chancellor of New York suggested that the Constitution's reference to citizen incorporated the British rule, but that is far from obvious. Nothing in the records of the Constitutional Convention supports that conclusion, and the British rule would be a poor fit as an interpretation of the term citizen in the provisions governing the qualifications of members of Congress and the President. An early draft of the Constitution provided that a representative must have been a citizen of the United States for at least 3 years, but there was opposition to this provision. One delegate argued that 3 years was not enough, in part because a rich foreign nation, for example Great Britain, might send over her tools who might bribe their way into the legislature for insidious purposes. In response, the delegates voted to require 7 years citizenship for representatives and 9 years citizenship for senators. The Presidential Eligibility Clause, Article 2, subsection 1, Clause 5, had a similar aim, but it went even further. Not only does it require 14 years residence, it also requires that a president be a citizen from birth. Its purpose was to prevent a person with possible foreign loyalties from becoming president, and the British rule hardly seems consistent with that aim. No case concerning the meaning of the term citizen in any constitutional provision reached the Supreme Court until Dred Scott v. Sandford. Before then, the British rule did figure in a handful of antebellum Supreme Court decisions, but none of these addressed any constitutional question, and most appeared to have regarded the British rule as part of state law on eligibility to inherit property. Not only were there no Supreme Court decisions on the constitutional question, there was not much litigation of any kind on the question of United States citizenship. Both Lynch in 1844 and an 1862 opinion by Attorney General Bates expressed surprise at this dearth. And in our time, when the difference between citizenship and alienage is a hot issue, this dearth may seem very strange, but some obvious explanations come readily to mind. The question of citizenship came up regularly in cases in which the jurisdiction of a federal court was invoked based on diversity of citizenship, but the issue in those cases was whether one or more of the parties were citizens of a particular state, not whether they were citizens at all. A party wishing to challenge federal jurisdiction had no incentive to argue that an adverse party was an alien because both Article 3 of the Constitution and subsection 11 of the Judiciary Act of 1789 conferred jurisdiction over cases between citizens and aliens. Therefore, an adverse party who showed that a supposedly diverse citizen was actually not a citizen at all would have confirmed the jurisdiction he sought to oust. As for the other constitutional provisions that use the term citizen, it appears that the question simply did not come up. A reason why the issue did not arise regarding the qualifications of members of Congress may be that foreign-born individuals who were interested in holding office could easily become citizens. Under the Naturalization Act of 1790, a foreigner became an American citizen simply by proving the 2 years of residence and good moral character. In the years before the Civil War, and indeed until many years thereafter, the distinction between citizens and aliens meant less than it does today. During that period, immigration was unrestricted, so aliens could come and stay as long as they wanted. And in an era When transatlantic travel was slow, unpleasant, expensive, and sometimes perilous, it is likely that the vast majority of those who sailed across the Atlantic intended to remain. If that was their choice, naturalization, as noted, was easy. And if, for whatever reason, a person who intended to make a permanent home here did not do what was needed to apply for naturalization, the lack of citizenship did not matter as much as it would in later years. In some places, aliens could even vote and hold elective office. Whatever the reasons, the issue of citizenship came up in only a few cases, and except for those involving the question of citizenship for free black people, the cases did not involve questions of much public importance. Legal treatises, to be sure, included comments on birthright citizenship, but those comments were not informed by judicial decisions. The important point for present purposes is that during the antebellum period, there was no settled understanding about the meaning of citizenship under the Constitution, and there certainly was no settled understanding about the citizenship of a child born on United States soil to parents whose presence in the country was unlawful. That was a situation that could not have occurred. After the Civil War, Congress faced enormous challenges, and one of these was ensuring that all black Americans, both the newly freed slaves and those who were free before the war, would be treated as citizens of the United States and of the states in which they lived. Congress addressed that issue in the landmark Civil Rights Act of 1866 and then again in the 14th Amendment. For the first time in the nation's history, these enactments provided a national rule on citizenship, and the meaning of that rule is the question that the court now addresses. In tackling that question, an avowedly textualist court should start by carefully examining the text of the Citizenship Clause of the 14th Amendment. See FDA versus Alliance for Hippocratic Medicine. We begin, as always, with the precise text of the Constitution. Dobbs v. Jackson's Women's Health Organization, constitutional analysis must begin with the language of the instrument, quoting Gibbons v. Ogden, and then see District of Columbia v. Heller, beginning with an analysis of the Second Amendment's text. The clause states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Thus, birthright citizenship has two separate elements. First, a person must be born in the United States, and second, he or she must be subject to the jurisdiction thereof. It is therefore critical to ascertain the meaning of subject to the jurisdiction thereof. And that is no easy task because, as we have often remarked, jurisdiction is a term of many meanings. We must therefore determine which one applies here. If subject to the jurisdiction of the United States had been a term of art during Reconstruction, we would presumably hold that the phrase has that meaning in the 14th Amendment. But that phrase was not a term of art, and the court does not claim it was. If the Citizenship Clause set out specifically named exceptions to the general rule of citizenship by birth, our job would be easy. We would follow those exceptions. But the Citizenship Clause is framed differently. It sets out a general rule. Citizenship is not conferred upon a person born in the United States unless that person is also subject to the jurisdiction of the United States. By its terms, that rule applies across the board. And when a legislative body chooses to adopt a generally worded rule, we apply it in all circumstances that fall within the rule, not just those that were on the minds of the legislators at the time of adoption. We approach constitutional interpretation similarly. So what does the phrase subject to the jurisdiction thereof mean? Unfortunately, the text of the 14th Amendment does not provide a definitive answer, but it supplies two valuable clues. First, subsection 1 of the 14th Amendment uses the word jurisdiction twice, once in the Citizenship Clause and once in the Equal Protection Clause, and the wording of the two clauses differs. The Citizenship Clause applies to those subject to the jurisdiction of the United States, whereas the Equal Protection Clause applies to any person within a state's jurisdiction. When Congress uses disparate language, especially in the same provision, we presume that the difference matters. Therefore, we must presume that the scope of the two provisions is different. Second, the phrase subject to the jurisdiction of the United States applies not only to those who are born in this country, but also to those who are naturalized. After all, Congress would not include both qualifiers unless they were both doing some work. Accordingly, there must be some people who are naturalized but are not subject to the jurisdiction of the United States. In other words, whatever subject to the jurisdiction of the United States means, it must mean something that is not inherent in naturalization. Although the text of the 14th Amendment provides these clues, we must look beyond that text to find a full explanation of the phrase subject to the jurisdiction of the United States. The terms of the 1866 Civil Rights Act, CRA, provide that explanation. The CRA includes its own citizenship clause, and the circumstances surrounding Congress's adoption of the CRA and the 14th Amendment make clear that the two provisions were understood to be substantively the same. The 39th Congress debated the CRA from January to March 1866, when it was passed and sent to President Johnson for his signature. Congress debated the 14th Amendment from April to June 1866, when it was adopted and sent on to the states. Thus, during a 6-month period, the same Congress debated two provisions that addressed the very same question and adopted them both. Those circumstances in themselves make it highly unlikely that the two provisions differed in substance. In addition, one of the chief reasons for the adoption of the 14th Amendment was to prevent the CRA from being held unconstitutional. President Johnson had cited the unconstitutionality of the CRA as one of the reasons why he vetoed it. If the CRA had granted birthright citizenship to persons who were not entitled to citizenship by birth under the 14th Amendment, there would still have been doubts about the CRA's constitutionality. So, at a minimum, the 14th Amendment's text had to be at least as generous as its CRA counterpart. Moreover, following the ratification of the 14th Amendment, Congress reenacted the CRA in 1870. That reenactment would have been pointless if the CRA's test for birthright citizenship were less generous than the 14th Amendment's. For all these reasons, it is abundantly clear that the tests for birthright citizenship in the 14th Amendment and the CRA were substantively identical. I therefore turn to the text of the CRA's citizenship provision. It provided that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. That language preserved two exceptions that were well known and well accepted at the time. The first was for the children of diplomats. The second was for Indians who had not left their traditional way of life and continued to live with other members of their tribes under the governance of tribal leaders. The exclusion of these tribal Indians from citizenship followed from Article 1's apportionment clause, which says that congressional representatives and direct taxes shall be apportioned among the several states, according to their respective numbers, excluding Indians not taxed. In the Constitution, just as during the Revolution, taxation and representation went hand in hand. Indians who lived apart under tribal rule were not considered part of the political community. As Chief Justice Marshall explained, Indian tribes were domestic dependent nations. Cherokee Nation v. Georgia. Chancellor Kent provided a similar description of Indian status in the early republic. Though born within our territorial limits, the Indians are considered as born under the dominion of their tribes. They are not our subjects, born within the purview of the law, because they are not born in obedience to us. They belong by birth to their own tribes. Because Indians who lived apart under tribal rule were not considered part of the political community, they did not receive representation and they were not taxed. Due to this status, it appears to have been accepted that tribal Indians and their children, although born on U.S. soil, were not citizens. The other exception for the children of diplomats was one that had been recognized under the British rule and was endorsed by leading authorities on the law of nations. This was a minuscule category at best, and Congress could have preserved the exception with narrow language applicable only to the members of that group. For example, it could have said something like this: all persons born in the United States, excluding Indians not taxed, and the children of foreign diplomats, are hereby declared to be citizens of the United States. Congress did not take that approach. It chose instead to identify what it understood to be the characteristic that called for the exception and to deny birthright citizenship to anyone who shares that characteristic. That characteristic, as Congress saw it, was being subject to any foreign power. With this understanding of the CRA's citizenship test in mind, we may return to the text of the 14th Amendment. When Congress framed the citizenship test in the 14th Amendment, it consolidated the CRA's two exceptions to citizenship by birth, for Indians not taxed, and those subject to any foreign power. The 14th Amendment used the phrase subject to the jurisdiction of the United States to cover both of those exceptions. Therefore, a person who is subject to any foreign power is not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. This unique formulation uses the term jurisdiction in a very specific sense. It refers to a form of jurisdiction that is exclusive, that is not in any way limited by any power possessed by any foreign country. The children of diplomats were not subject to this complete jurisdiction because they were citizens or subjects of the countries represented by their fathers and thus bore duties to those countries. Likewise, tribal Indians were not subject to the United States' exclusive jurisdiction because they were bound to obey tribal law, but they were certainly subject to the jurisdiction of the United States in a different sense of the concept. That is, they were subject to regulation by the federal government. After all, their tribes were domestic dependent nations. And even though the government allowed tribes a large measure of self-government, it consistently asserted its jurisdiction to intervene. In 1817, for example, federal criminal jurisdiction was extended to many crimes committed within the Indian country. And the Indian Trade and Intercourse Act of 1834 extended that jurisdiction. In addition, treaties repeatedly described tribes as within the jurisdiction of the United States. For example, a treaty between the United States and the Navajo tribe of Indians, ratified September 24th, 1850. A treaty between the United States and the Utah Indians, ratified September 9th, 1850. Treaty between the United States and the Apache Nations of Indians, ratified March 23rd, 1853. Likewise, the court held that Indians were within our jurisdiction and subject to our laws. Thus, tribal Indians were subject to the jurisdiction of the United States in the sense that they could be and were governed by federal law, but they were not subject exclusively to federal law because they were also governed by tribal law. For that reason, their children did not become citizens at birth. This understanding of the phrase subject to the jurisdiction thereof also explains why naturalized citizens must forswear all other allegiances when they become United States citizens. From the earliest days of our republic until now, Congress has required naturalized citizens to renounce and abjure absolutely and entirely all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty of whom or which the applicant was before a subject or citizen. See United States Code, subsection 1448A, active January 29th, 1775. He doth absolutely and entirely renounce and abjure all allegiance and fidelity to every foreign prince, potentate, state, or sovereignty, whereof he was before a citizen or subject. Such an oath would not be necessary if the Constitution permitted anything less than exclusive jurisdiction. In sum, the 14th Amendment confers citizenship on a person who is born in this country or naturalized only if that person is also not subject to any foreign power. The court interprets subject to the jurisdiction thereof differently. In its view, the phrase simply means subject to the laws that apply to everyone who is present within the country's borders. That interpretation, however, presents fatal problems. First, it gives the 14th Amendment's citizenship test a meaning that plainly differs from that in the Civil Rights Act, even though it is beyond any reasonable dispute that Congress did no such thing. To justify its departure from the Civil Rights Act, the court argues that the act raises more questions than answers, and that the 14th Amendment better expresses the views of the Reconstruction Congress. But, as I see it, deciding whether someone is subject to any foreign power raises far fewer questions than deciding whether that person is subject to the jurisdiction of the United States. The court's commitment to avoiding the straightforward text of the Civil Rights Act strongly suggests that something is amiss. Second, the court cannot explain why the 14th Amendment did not confer citizenship on children born in the United States to tribal Indians. As explained, federal law governed those children and their parents to the extent the federal government wished. If the court were right that the Citizenship Clause applies to anyone who is born here and is subject to our laws, then the 14th Amendment would have conferred citizenship on all tribal Indians. But the exception for tribal Indians was well established at the time and remained until Congress eliminated it by statute. See Indian Citizenship Act of 1924, that all non-citizen Indians born within the territorial limits of the United States be and they are hereby declared to be citizens of the United States. Third, the court cannot explain why the phrase subject to the jurisdiction of the United States applies to naturalized citizens. All naturalized citizens, like everyone else who is present in this country, must obey the law. So if that phrase meant what the country thinks, it is superfluous. By contrast, if it means not being subject to any foreign power, it serves an identifiable purpose and explains why the naturalization statutes, both before and and after the adoption of the 14th Amendment, required those seeking naturalization to renounce allegiance to any other country. For these reasons, the court's interpretation of the 14th Amendment's Citizenship Clause fails on textualist grounds. The court does not confront these problems because it pays little attention to the constitutional text. Instead of performing its own textual analysis, the court leans on precedent that glosses the text, but none of the cases it cites analyzed the text of the 14th Amendment's Citizenship Clause. The court first cites Lynch, but as Justice Thomas comprehensively explains, any reliance on Lynch is misplaced. Next, the court turns to Schooner Exchange v. McFadden, which held that a ship of war of a friendly power could enter a United States port without the risk of seizure. Neither that holding nor the reasoning in Chief Justice Marshall's opinion for the court has any bearing on the meaning of the terms of the 14th Amendment's Citizenship Clause. The question in Schooner Exchange concerned the circumstances under which a sovereign is deemed, under the law of nations, to have implicitly waived part of its otherwise complete sovereignty over its territory. The 14th Amendment, however, does not waive any part of the United States' sovereignty. It is true that the government has waived its sovereign right to subject covered diplomats and their dependents to legal process, but that is done by a statute, 22 U.S.C. subsection 254a. That implements treaty obligations and respects long-established norms of international law. Neither that statute nor any treaty into which the United States has entered, nor any international law norm requires the United States to confer birthright citizenship on any child born here to alien parents. The interpretation of the 14th Amendment's Citizenship Clause set out above is based entirely on the text and legal context of that amendment and the Civil Rights Act of 1866. It does not depend in any way on the record of the debates on those two enactments. But to the extent that congressional debates on the 14th Amendment and the Civil Rights Act are probative, they strongly support my textual interpretation. The clearest evidence was provided when the 14th Amendment's Citizenship Clause was presented in the Senate. As originally drafted, the 14th Amendment did not define citizenship. Senator Jacob Howard introduced an amendment that remedied that problem. Senator Lyman Trumbull, the author of the Citizenship Clause in the Civil Rights Act, explained just what the new amendment meant. The provision is that all persons born in the United States and subject to the jurisdiction thereof are citizens. That means subject to the complete jurisdiction thereof. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. This language, he said, was better than the language in the Civil Rights Bill, but the object to be arrived at is the same. Senator Howard concurred entirely in Senator Trumbull's interpretation. Thus, the authors of the two major provisions defining United States citizenship agreed that birthright citizenship required complete allegiance. Other senators quickly agreed. Senator Doolittle called the Civil Rights Act the forerunner of this constitutional amendment, and said the Civil Rights Bill undertook to do this same thing, as the 14th Amendment. Senator Reverdy Johnson, a member of the Joint Committee on Reconstruction and former Attorney General, pointed out that all that this amendment provides is that all persons born in the United States and not subject to some foreign power, for that, no doubt, is the meaning of the committee who have brought the matter before us, shall be considered as citizens of the United States. So too, Senator Williams remarked that he understood the words here, subject to the jurisdiction of the United States, to mean fully and completely subject to the jurisdiction of the United States. Public commentary on the Citizenship Clause exhibited a similar understanding. Those who disagree with this interpretation have not found any statement in which another senator expressly disputed Senator Howard's and Senator Trumbull's interpretation of the amendment. They muster a collection of statements that provide some support for their position, but it is a mistake to attribute too much weight to extemporaneous oral statements, which are often phrased in ways that are not precise. And a single member's interpretation of a provision may not be shared by a majority. I do not suggest that we should base our decision in this case on statements made during the legislative debates on the 14th Amendment and the Civil Rights Act. Reliance on any form of legislative history is always problematic for reasons that are familiar. See A Matter of Interpretation by Antonin Scalia. Floor statements by individual legislators rank among the least illuminating forms of legislative history. Here, the only form of legislative history we have consists of floor statements. We should base our decision on the firm ground provided by the constitutional text, but if we look beyond the text, the congressional debates and public commentary confirm that the Citizenship Clause requires complete allegiance. After the ratification of the 14th Amendment, Supreme Court cases quickly acknowledged the interpretation set out above. In the slaughterhouse cases, the court wrote that the amendment's citizenship clause was intended to exclude from its operation children of citizens or subjects of foreign states born within the United States. And then see also Minor v. Happersett, expressing doubts about the citizenship of children who are born to non-citizen parents. Justice Gray's opinion for the court held that the Citizenship Clause requires not merely that a person born in the United States be subject in some respect or degree to the jurisdiction of the United States, but that he be completely subject to the United States political jurisdiction and owe the country his direct and immediate allegiance. For that reason, John Elk, despite being born within the territorial limits of the United States, did not have a valid claim to citizenship by birth because he had been born on a reservation of tribal Indians. Indian tribes, the opinion explained, were alien nations and their members owed immediate allegiance to the several tribes. Although Elk had voluntarily separated himself from his tribe and taken up his residence among the general public, he was born owing immediate allegiance to the tribe and, as a result, was not entitled to birthright citizenship under the 14th Amendment. That was the state of the court's case law until Wong Kim Ark turned it in a different direction. That case provides the strongest support for today's decision, but its holding is not controlling, and I would not allow the meaning of American citizenship to be forever dictated by the opinion's dubious dicta. Wong Kim Ark cautioned against assigning too much weight to dicta, and it is appropriate to apply that same advice to the opinion in Wong Kim Ark itself. The court leans heavily on Wong Kim Ark, which certainly displayed the fruit of considerable research on a range of subjects, but it showed little respect for precedent. Justice Gray, the author of Elk, also wrote Wong Kim Ark, but he brushed Elk aside on the flimsy ground that it concerned only members of the Indian tribes and thus had no bearing on other children. Wong Kim Ark's treatment of the text of the 14th Amendment and its relationship with the Civil Rights Act's citizenship test was no better. Indeed, in reading the opinion, it is hard to escape the conclusion that it aimed to divert as much attention as possible from what those provisions actually say. The discussion of those provisions is broken up and interspersed with disquisitions on other matters. When the opinion finally turns to the text of the 14th Amendment, it summarily concludes that subject to the jurisdiction thereof in the Citizenship Clause has the same meaning as the phrase within its jurisdiction in the Equal Protection Clause, but the opinion makes no effort to explain why Congress might have chosen to use different language in two places within the same provision to express the same concept. As we have often noted, we usually presume that differences in language convey differences in meaning. Nor does the opinion explain why Elk had interpreted subject to the jurisdiction thereof very differently. As for the phrase not subject to any foreign power in the Civil Rights Act, Wong Kim Ark tries two different tacks. First, it suggests that the phrase means the same thing as subject to the jurisdiction thereof in the 14th Amendment. But if, as the opinion maintains, subject to the jurisdiction thereof essentially means subject to civil and criminal liability for breaking the law, then subject to the jurisdiction thereof does not mean the same thing as not subject to any foreign power. Everyone within the country's borders, except those with diplomatic immunity, may be held civilly or criminally liable for violations of the law, but many aliens within our territorial limits are also subject to a foreign power. For example, their home country, because they must follow that country's laws when they are abroad. Some countries, Mexico for example, even mandate military service by those living abroad. So, in ordinary usage, being within the United States and having an obligation to obey United States law while here is definitely not the same as not being subject to any foreign power. Wong Kim Ark's fallback argument is no better than the first. The opinion speculates that Congress might have thought that not subject to any foreign power trimmed the birthright citizenship rule too much, and that this accounts for Congress's use of different language in the 14th Amendment. That suggestion flies in the face of all the reasons previously mentioned why the citizenship tests in the Civil Rights Act and the 14th Amendment must be understood to be substantively identical. That is the extent of Wong Kim Ark's analysis of the terms of the 14th Amendment's citizenship test, and I would not carve an interpretation of the citizenship clause in stone based on such dubious dicta. And dicta it is. Sometimes it is not easy to determine the exact contours of a decision's holding, but the opinion in Wong Kim Ark obviates that problem. At the end of the opinion, the court clearly spells out exactly what it held. A child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes, at the time of his birth, a citizen of the United States. Thus, the holding of the case was limited to a child born in the United States to parents who were not citizens but had established a permanent domicile and residence here. Many other key passages in the opinion confirm this fact. When the parents are domiciled here, birth establishes the right to citizenship. The Citizenship Clause includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Every citizen or subject of another country, while domiciled here, is within the allegiance and the protection, and consequently subject to the jurisdiction of the United States. Subjects of the Emperor of China, but domiciled in the United States, must be held to be subject to the jurisdiction of the United States. The court dismisses these pointed and repeated references to domicile, arguing that domicile was merely an incidental fact and not an element of the holding. But Justice Gray had a good reason for pointing out that Wong Kim Ark's parents had established their domicile here. A person's domicile is the place where he or she intends to live indefinitely. Therefore, the fact that they had established domicile here meant that they wanted to make the United States their home. It is telling that Justice Gray's statement of the holding also mentioned that Wong Kim Ark and his parents were Chinese. The British birthright subjecthood rule did not take account of the race or nationality of the alien to whom a child was born within the king's domain. See Calvin's case. So if the opinion aimed to adopt the British rule, with the one new exception for tribal Indians, there was no need whatsoever for the holding to say anything about the race of Wong Kim Ark or his parents. Yet it did so. And not only that, the opinion spent many paragraphs describing statutes, court decisions, and debates in Congress about the plight of Chinese immigrants. The opinion also properly stressed that the fundamental objective of the 14th Amendment was to protect the rights of people of all races. When we understand the situation Wong Kim Ark and his parents faced, their domicile in the United States takes on a special meaning. If they had been white or black, they could have applied for naturalization, but because they were Chinese, the law forbade their naturalization. By establishing domicile, they had done everything within their power to express their desire and intent to become Americans. If the court had not interpreted the Citizenship Clause in the way set out in the holding, the result would have been a population permanently caught in limbo. The Chinese immigrants who were lawfully present before the enactment of the Chinese Exclusion Act of 1882, as well as all their descendants, could never become citizens no matter how much they wanted to be Americans, no matter how deep their roots in this country, no matter how substantial their contributions to our society. Wong Kim Ark is therefore best understood as holding that people who are lawfully present here, establish the United States as their intended permanent home, and do everything within their power to become United States citizens, can be seen as no longer subject to any foreign power. Thus, their children are born citizens under the 14th Amendment. That interpretation of Wong Kim Ark is consistent with the decision's statement of its holding. It can be reconciled with the language of the 14th Amendment and the Civil Rights Act, and for the Chinese Americans of Wong Kim Ark's time, it was the interpretation that best implemented the 14th Amendment's promise of racial equality. Wong Kim Ark benefited Chinese Americans, but its impact on other immigrants was limited. For decades after that decision, immigration remained largely unregulated. During World War I, however, the federal government began to limit the flow of immigrants. In 1917, Congress passed a law that excluded all Asians, implemented a literacy test, and included a long list of criteria for admission. Later laws, most notably the Discriminatory Immigration Act of 1924, continued this trend by imposing quotas based on immigrants' country of origin. From that time until the enactment of the Immigration and Nationality Act of 1965, immigration, both legal and illegal, was light, and the number of Americans born abroad shrank from 13.9 million in 1920, when the population was just over 100 million, to less than 10 million in the 1960s, when the population grew to over 200 million. After 1965, however, immigration increased dramatically, and the problem of illegal immigration grew. The story of illegal immigration unfolds in four parts. First, illegal immigration emerged as a notable problem in the 1970s. Second, the federal government tried to deal with this problem in 1986 by implementing employer sanctions and amnesty for millions of immigrants. But that attempt failed. Third, the federal government, with help from this court, blocked border states from implementing their own solutions to a problem that hit them particularly hard. Meanwhile, other states, counties, and cities designated themselves sanctuary jurisdictions, thus encouraging illegal immigration. Finally, as a result of these developments, the number of illegal immigrants in this country exploded. Illegal immigration emerged as a national problem in the 1970s. After Congress passed the Immigration and Nationality Act in 1965, that act eliminated immigration quotas based on national origin and replaced them with a preference-based immigration system that included an overall cap of 290,000 immigrant visas per year. But demand for visas vastly outstripped supply, thus encouraging migrants to subvert the legal process. Many immigrants entered or remained illegally for economic reasons. In the United States, opportunities abounded to pick crops and to do other 3D, dirty, dangerous, and demeaning jobs. American employers were all too willing to hire employees who would work for less than the minimum wage and without the benefit of laws protecting employee rights. Yet even these poor working conditions surpassed those in the home countries of many immigrants. This situation created a strong incentive for immigration, both legal and illegal. As a result, immigration, both legal and illegal, soared. Demographers generally assumed that the size of the illegal immigrant population in 1960 was negligible. By the end of the 1970s, however, a conservative estimate of the number of illegal immigrants was 3 million. Early efforts to solve the illegal immigration problem failed. In 1977, President Carter proposed an immigration overhaul that floundered due to opposition from his own party's core constituencies, including labor unions, Hispanic groups, and environmentalists. In 1986, more than 20 years after passage of its last major immigration bill, Congress agreed to do something about illegal immigration. It passed the Immigration Reform and Control Act of 1986, IRCA. This court, in an opinion by Justice Stevens, described IRCA as a major statutory response to the vast tide of illegal immigration that had produced a shadow population of literally millions of undocumented aliens in the United States. IRCA made it unlawful to hire or to recruit or refer for a fee an alien knowing the alien is an unauthorized alien. To implement this program, IRCA required employers to review documents establishing identity, such as a driver's license, employment authorization, such as a social security card, or both, such as a U.S. passport. See also Kansas v. Garcia, describing IRCA employment verification system. IRCA also increased funding for border security and immigration enforcement. IRCA balanced harsher enforcement with a plan to legalize the status of millions who were living in the United States illegally. Immigrants could obtain legal status in two ways. First, they could file an application showing that they had resided in this country continuously since before 1982, had been physically present here since the date IRCA became law, November 6, 1986, and would be admissible if they were coming legally. Subsection 1255A, subsection A. Second, they could certify that they had resided in the United States for at least a year, had worked in agriculture for at least 90 days, and were admissible. Given the less stringent criteria for the latter legalization pathway, it proved much more popular. The number of applications under the agricultural pathway far exceeded estimates, at least in part because of fraud. Ultimately, almost 2.7 million illegal immigrants obtained legal status under the two pathways. Despite IRCA's ambitious aims, it failed to curb illegal immigration. The work verification and employer sanction system did not eliminate the strong economic incentive for illegal immigration. Immigrants easily forged, stole, or shared documents like photoless driver's licenses and social security cards to provide verification of identity and employment authorization to their employers. And the law supplied little reason for employers to smoke out these fraudulent documents. On the contrary, if an employer requested additional documentation, he or she faced penalties imposed to ensure that employers did not discriminate against foreign looking or sounding workers. Under enforcement of IRCA rendered its employer sanctions nearly toothless. IRCA's increased border enforcement did not help either. Although IRCA may have caused a short term decrease in migration, the law failed to discourage undocumented immigration in the long run. Congress has not passed comprehensive immigration legislation since 1986, in large part because voices across the political spectrum have criticized any attempts at serious reform. For example, President George W. Bush's immigration reform proposal met with skepticism from conservatives who argued that it amounted to amnesty for illegal immigrants. Meanwhile, liberals and labor unions criticized the plan for not going far enough to address illegal immigrants' plight. When Congress failed to solve the illegal immigration problem, states stepped in. California led the way in 1994 with Proposition 187. That law stated every law enforcement agency in California shall fully cooperate with the United States regarding any person who is arrested if he or she is suspected of being present in the United States in violation of federal immigration laws. Proposition 187 also excluded illegal immigrants from public social services, publicly funded healthcare services, and, most controversially, public education from elementary school through university. Although California voters overwhelmingly approved Proposition 187, the measure never went into effect. A federal district court enjoined the law, and then a new governor settled the lawsuit. As illegal immigration continued to climb, states tried to lessen its effects. For example, Arizona passed a law in 2007 that allowed courts to suspend or revoke business licenses for those who employed illegal immigrants. The Chamber of Commerce sued, arguing the law was preempted, but this court disagreed. Following that victory in this court, states worked to ameliorate the illegal immigration problem. In 2008 alone, 13 states passed laws punishing employers for hiring unauthorized workers. Arizona went further in 2010 with a law that punished illegal immigrants for working or failing to register. The law also gave law enforcement the ability to arrest, based on probable cause, those suspected of violating the immigration laws, and requiring verification of individuals' immigration status during stops, detentions, and arrests. At the United States' urging, the court held that federal law largely preempted Arizona's efforts. See Alito's concurring opinion, concurring in part and dissenting in part, arguing that the Arizona law was largely consistent with federal law. The litigation between Arizona and the United States inaugurated an era in which the federal government and states resisted each other's efforts to address illegal immigration. Texas, in particular, repeatedly challenged federal immigration policies that the state alleged increased illegal immigration, but the state met with little success in this court. The trouble began when Texas unsuccessfully challenged in the 2021 termination of an earlier administration's border enforcement policies. See Biden v. Texas. The state also lost in this court when it tried to stop the government's deprioritization of immigration enforcement against some criminal aliens. See United States v. Texas. This court thus greenlighted a policy that prohibited immigration officials from making enforcement decisions based solely on criminal convictions, no matter how serious. Citing Texas v. United States. For its part, the federal government sued to stop Texas from implementing its own solutions to illegal immigration. When illegal entrants overran Texas border towns, the state erected barbed wire fencing, but Border Patrol officers cut or displaced the fencing. As the lower courts found and a video confirms, the federal officers installed a climbing rope on the Texas side of the river and made no effort to turn back a stream of migrants who were wading across the Rio Grande. Instead of processing the entrants, border officers simply told them to walk a mile or more without supervision to the nearest immigration processing center. Then, from the comfort of chambers more than 1,000 miles from the southern border, this court sided with the federal government, allowing immigrants to pour into the state. Likewise, the government sought to stop Texas from criminalizing illegal entry or reentry into the state. Although the court denied that application, the federal government's message was clear. Even in the midst of a crisis, self help is not an option. In short, the executive branch and this court left border states, the ones that bear the brunt of the country's illegal immigration problem, the ones that bear the brunt of the country's illegal immigration problem. See Arizona, Scalia concurring in part and dissenting in part, practically defenseless against illegal immigration. Meanwhile, other states, counties, and cities encouraged illegal immigration by becoming sanctuary jurisdictions. These jurisdictions prohibit their law enforcement officers from cooperating with federal immigration officials. They often refuse to share information with federal immigration officers or to honor the federal government's request to briefly extend the detention of those suspected of being in the country illegally. Many also prohibit police officers from asking about immigration status. San Francisco passed some of the first such ordinances in the 1980s. After 2008, the number of jurisdictions with sanctuary policies increased significantly. According to a list published by the Department of Justice, 11 states and the District of Columbia, 3 counties, and 18 cities are sanctuary jurisdictions, but the number is likely significantly higher. See, for example, Delgado listing over 150 sanctuary jurisdictions. Congress's failure to act, the executive branch enforcement policies, and frequent opposition to state solutions, and some jurisdictions' policies have resulted in a massive increase in the number of illegal immigrants living in this country. According to leading demographers at Pew Research Center, the illegal immigrant population grew by more than 2 million between 2022 and 2023, bringing the total number of illegal immigrants in this country to 14 million. Demographers estimate that 9% of all births in the United States in 2023 were to mothers who were in the country illegally or on a temporary basis. These numbers are striking, and after 2023, the trend appears to have intensified. Between July 2023 and March 2024, the overall foreign-born population of the United States increased from 48.5 million to 51.6 million. An unprecedented increase of 3 million immigrants in 9 months. Much of this growth was driven by the admission of unauthorized immigrants with temporary deportation protections. As a result of the events of the past 50 years, the United States now has a huge contingent of people who entered or remained in this country illegally, as well as a large group of people who were born here to such parents. The court's interpretation of the 14th Amendment makes all the members of this latter group citizens. Many of those who have grown up here now have a strong moral claim to be allowed to remain, but that is a matter that the 14th Amendment, when properly interpreted, leaves to Congress. As shown in Part 2, a person who is born in the United States is made a citizen by the 14th Amendment only if that person was also subject to the jurisdiction of the United States. And that phrase means subject to the jurisdiction of the United States alone and not subject to any foreign power. A great many persons who are born here to illegal immigrant parents fail this test because at birth they are automatically made nationals of their parents' native country and, as a result, incur duties to that country. This means that they are subject to a foreign power and are thus not subject to the jurisdiction of the United States within the meaning of the 14th Amendment. This is illustrated by the laws of countries on the list of those from which the greatest number of illegal immigrants come. Mexico is at the top of that list, and under Mexico's constitution, the child of a Mexican parent can become a Mexican national at birth and acquires certain duties to the government. Among these are the obligation to receive military training and to join the National Guard. Guatemala is second on the list, and its constitution also confers Guatemalan nationality on a person born abroad to a Guatemalan parent. All Guatemalan nationals owe certain duties to the government. At the age of 18, a Guatemalan national automatically becomes a Guatemalan citizen, and thereby acquires additional obligations. El Salvador is also among the top 5, and its constitution provides that children of a Salvadoran father or mother born in a foreign country are Salvadorans by birth. Upon reaching the age of 18, these children incur an obligation to serve in the military, as well as other duties, including the duty to serve the state in conformity with the law. Many other countries among the top 10 have similar laws. Respondents' claim in this case is that the executive order
Respondents' claim in this case is that Executive Order number 14160 is unconstitutional on its face. To prevail on this facial claim, they must show that no set of circumstances exists under which the executive order would be valid. And because the order is valid as applied to nationals from the countries discussed above, the claim should fail. In all likelihood, the executive order is also constitutional as applied to nationals from a great many other countries, but no such showing is needed here. Indeed, showing merely that the executive order is valid as applied to a child born to a birth tourist would be enough to defeat respondents' facial claim. That is why the court goes out of its way to hold that even a child born to a mother who is here for only a brief time is a citizen under the 14th Amendment. The court's interpretation is not only contrary to the original meaning of the 14th Amendment, it produces grotesque results. While foreigners who wish to immigrate lawfully must sometimes wait for many years, a child born here to a birth tourist is automatically a citizen. The court's interpretation also has national security implications. Suppose that a person's only connection to this country is that he was born here to a mother who was present just long enough to give birth and then quickly returned to her native country. Suppose that country is a strategic adversary or enemy of the United States. Suppose the child never visited the United States while growing up and was inculcated with hatred of this country. According to the court, that person is a citizen of the United States. He can enter and leave the country as he pleases. He can travel the world on a United States passport. Even if he plots to harm this country, he cannot be deprived of his status as a citizen, at least under current precedent. The court's interpretation saddles this country with an ancient British rule that even the United Kingdom has abandoned, as have other countries whose legal systems share the same pedigree. The court's interpretation preserves a powerful incentive to enter or remain in this country illegally. Immigrants naturally prefer affluent countries where economic opportunities are available. Other than Canada, the United States will be the only affluent nation where birth alone is enough to establish citizenship. If the 14th Amendment required these results, the country would have to live with them or amend the Constitution. But the 14th Amendment does not include the rule the court now imposes on the country. In my judgment, the court has made a mistake that will seriously affect the country's future. For that reason, I respectfully dissent. Justice Gorsuch dissenting. At the heart of today's dispute lie two competing views of the 14th Amendment's Citizenship Clause. On one account, the clause incorporated the English common law rule of jus soli, literally the right of the soil. That rule, developed in feudal times, had more to do with being a subject than a citizen. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed it to the king, and it was born with the child and only ended in the grave. On the other account, the clause adopted a distinctly American settler's view of citizenship, one that promises the full dignity and glory of American citizenship to any child born in this country to parents who have made this nation their permanent home regardless of their race, religion, or national origin. To my eye, the latter understanding better accords with the clause's original public meaning, and that leads me to join Justice Thomas's dissent. I write only to emphasize a few points. First, the understanding Justice Thomas and I share of the Citizenship Clause is consistent with the court's holding in United States v. Wong Kim Ark. That case involved parents born in China who had made their home in this country lawfully, even though they never became naturalized citizens, and statutes then, in effect, made that impossible. The question the court faced was whether the parent's child born in this country was himself a citizen. The government argued that the child was not a citizen because his parents were not. This court rightly rejected the government's position. Throughout history, many other nations have restricted citizenship by birth to the children of citizens. But the American settlers' view of citizenship, reflected in the Citizenship Clause, is not so parsimonious. What matters isn't whether a child's parents are citizens. What matters is whether they, and by law their child at birth, have made this place their home and are thus domiciled within the United States. Second, respondents chose to pursue a facial challenge to the executive order at issue in this case and secured below a preliminary injunction barring every one of the order's potential applications. Under this court's precedents, we can sustain that injunction only if no set of circumstances exists in which the order may be applied lawfully. That is a demanding standard, and it is not met here. Among other things, the executive order holds that children born to temporary visitors in this country, whether here lawfully or unlawfully, are not citizens. And at least to that extent, the order is consistent with the Citizenship Clause as Justice Thomas and I read it. By definition, temporary visitors to this country do not choose to make a permanent home here, and their children thus cannot claim the privilege of citizenship. Because the executive order is lawful, at least to this extent, respondents' facial challenge must fail. Finally, just because the executive order has some lawful applications and can survive a facial challenge does not mean it is lawful across the board and immune from narrower legal challenges. Besides addressing temporary visitors, the order also denies the benefits of citizenship to children born in this country to parents who make their permanent home here, but do so in defiance of federal immigration laws. The government insists that aspect of the order can survive any possible legal challenge. 2. Because individuals can secure domicile in this country only if they do so in compliance with federal law. About that, however, I harbor doubts. Perhaps Wong Kim Ark does not squarely foreclose the government's position. After all, that case addressed a child born to parents who lawfully resided in this country. Still, I wonder, is a child born here to parents who have long chosen to make this nation their permanent home not a citizen under the 14th Amendment solely because his parents' presence violates statutory law? If those parents are not domiciled here, then where are they domiciled? And if the answer is nowhere, how can we reconcile that conclusion with this court's long-standing recognition that every person is domiciled somewhere? Because the executive order is not facially invalid, these questions may not be properly before us. But their answers are undeniably important to a nation committed to a view of citizenship open to all children born here to parents who can call this country their home. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and we'll be happy to take a look. Thank you.